Good afternoon, guys. This is Attorney Matt Palu-ay. This is Law and Sales, and this is the lecture after midterms. All right, let's go. And we are still in Obligations of the Vendor, Chapter 4. We finished with Article 1537 last time, so we begin with Article 1538 this time. So, going back, this is the Law and Sales. We have 10 chapters, and we are in Chapter 4, Obligations of the Vendor. So, this is found in Article 1495 to 1581. So, the Obligations of the Vendor is divided into 3 sections. The first is General Provision, second is Delivery of the thing sold, and the third is Conditions and Warranties. Okay, so we go straight to Article 1538. In case of loss, deterioration, or improvement of the thing before delivery, the rules in Article 1189 shall be observed. Ang ibig sabihin nito, kung nagkaroon ng sira o kaya bumaba yung value o nag-deteriorate or nag-improve yung bagay na dapat i-deliver, yung rule sa Article 1189 will be observed. Okay? So, delivery. Pag narinig mo yung salitang delivery, ang unang papasok dapat sa isip mo is yung stages of a contract. So, you have your negotiation stage. Yan yung nagtatawaran kayo. And then, yung second is yung perfection stage. Yan yung nag-agree na kayo kung magkano ba yung presyo at kung ano yung item na bibilhin. At yung number 3 is consummation. Yan yung delivery. Ibig sabihin na na-consummate na, nagbigayan na kayo nung nagawa na ninyo yung obligation ng bawat isa. Okay? So, halimbawa, S sold his car to B. So, si S, siya yung seller. Ngayon, si B, siya yung buyer. Ngayon, ito, ang tawag mo dito ay contract of sale of a car. So, sa contract of sale of a car, may obligation ba dito? Ang sagot is, yes, definitely. Merong obligation dito. At i-relate natin ito doon sa sources of obligation. Kung naalala nyo pa yung obligations and contract ninyo, what are the sources of obligation? Diba, nakalagay doon, you have contracts. Diba? Sources of obligation would be law, contracts, quasi-contracts, delicts, and quasi-delicts. So, dito, papasok yung contract. So, ang kontrata ay isang source ng obligation. Okay? So, dito, ano ba yung source or ano ba yung obligation rather? Kasi ang source is yung kontrata mismo yung kasunduan. So, dito, sa kontrata na to, nag-arise yung obligation. Ano ba ang obligation dito sa contract of sale of a car? Dito sa contract of sale of a car ay hindi lang isang obligation ang meron. In actuality, may dalawang obligations dito. Yung una, yung obligation ng seller kay buyer, which is the delivery of the car. On the other hand, may second obligation dito. Yan naman yung obligation ng buyer kay seller na bayaran siya ng pera. So dito sa 1538, ang kino-contemplate na situation dito is yung obligation ni seller kay buyer na i-deliver yung sasakyan. Okay? So, again, yung obligation na tinutukoy dito is yung obligation ni seller na i-deliver kay buyer yung car. So, kapag titignan mo yung particular obligation na yon, sino doon ang debtor at sino ang creditor? Sa instance na to, ang debtor ay si seller kasi siya yung may pagkakautang na i-deliver ang sasakyan. At ang creditor naman ay si buyer dahil si buyer ang tatanggap ng sasakyan. Okay, so i-relate natin ito sa Article 1189 ng Civil Code. Ano ba nakalagay doon sa Article 1189? Ang sabi doon ay, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Ulitin ko. If the thing is lost without the fault of the debtor, the obligation is extinguished. So, kung i-relate mo yan dyan, kung ang sasakyan ay nasira bago yung delivery at walang kasalanan si seller, ibig sabihin, walang ibig sabihin, the obligation will be extinguished. Ibig sabihin, walang kasalanan si seller. Kasi in this case, si seller yung debtor eh. Diba? Ulitin ko ha. Article 1189 says that if the thing is lost without the fault of the debtor, in this case, yung debtor yung seller, the obligation shall be extinguished. So, the obligation is the delivery of the car. Right? If the car is lost, kasi yun yung thing. If the thing is lost without the fault of the debtor. So if the car is lost without the fault of the debtor, which in this case is the seller, the obligation is extinguished. Meaning, wala nang obligation si seller na i-deliver yung sasakyan. Pero si buyer may obligation pa rin na magbayad. Kapag titingnan mo yung sitwasyon na to, parang kawawang-kawawa naman talaga si buyer, di ba? Sa totoo lang, nag-a-agree nga ako na kawawa si buyer. Pero yan yung ating nakalagay. Yan yung nakalagay sa ating civil code. Yung pangalawang scenario naman, ulit, the car is lost or destroyed, pero ito may kasalanan si seller. So, in this case, tama lang naman na si seller talaga ay magbayad ng damages. Sa number 3, the car suffers deterioration. Again, without the fault of the seller. In this case, the buyer suffers impairment. So, if the car suffers deterioration or damage with the fault of the seller, so here, the buyer may choose to cancel by rescinding the contract or still continue or proceed with the contract through what we call specific performance. But in both cases, he can ask for damages from the seller. Kasi si seller yung may kasalanan, di ba? So, sana so far na susundan pa ninyo. Number 5. The car improved without the intervention of S. Say, the market value of the car increased. So, generally, halos lahat ng sasakyan, kapag nilabas mo yan sa kasa, bumabagsak talaga yung market value niyan. Parang sabi nga nila, once the car goes out of the shop or from the dealer, it automatically loses 10 or 20% of its value. So, ano yung situation na yung car naman, yung value ng car ay nag-improve? Siguro baka yung car is a luxury car, di ba? Or a vintage car. Baka tumaas yung value kasi it's no longer produced, di ba? Posibleng ganun. At any rate, if the value of the car increases, only the buyer will inure the benefit, meaning siya lang yung mag-gain. Kasi, in the same line na kung nasira yung sasakyan, siya din yung magsasuffer ng loss. Kung tumaas yung value, siya yung magbe-benefit dun sa gain. Number 6, the car improved with the intervention of S. Meaning yung seller, sabihin natin pinimp niya yung car, nilagyan niya ng mugs, etc. At saka ng magandang sounds. In this case, S shall have the right to use of rack with respect to the improvement. Ibig sabihin yan, may karapatan si seller na gamitin yung improvement. Pero, how that is, I honestly do not know kung paano gagawin. At any rate, ito yung nakalagay sa ating batas. So, ito yung pinag-aaralan natin. As to the practicality of it, parang it's quite difficult to apply it. So, that's 1538. Okay, so let's proceed to 1539. Okay, this talks of sale of real property by unit of measure or number. The entire area stated in the contract must be delivered. If the entire area stated in the contract cannot be delivered, the buyer may either rescind the contract provided that 1/10 of the value or 1/10 of the area is lacking, or demand the proportional reduction of the price. Okay, napakasimple lang nito guys. Ito, pinag-uusapan natin ay ang bentahan ng isang real property o lupa. Pwedeng condominium, pero siguro mas applicable sa article na ito ang isang lupa. Ang nakalagay dito, yung entire area na nakalagay dun sa kontrata, dapat i-deliver yon. So, in this case, halimbawa yung kontrata ninyo, sabihin natin ikaw ay bumili ng 1,000 square meters na property. Pero, hindi dineliver yung buong kontrata, yung buong lupa. Hindi i-deliver yung buong 1,000 square meters. Kulang. Ano ang remedy mo? So, ang sabi dito, number 1, pwede kang mag-rescind ng sale. Okay? Ibig sabihin nun, ika-cancel mo altogether yung sale. Pero, ang condition nun, dapat 1/10 or more nung value or nung area yung kulang. So, halimbawa, yung property 1,000 square meters at ang i-deliver lang sa'yo is 900 square meters. Pwede mong i-cancel yon. Kung less than 900, pwede mo pa rin i-cancel. Provided that 1/10 of the area. So, ano ba yung 1/10 ng 1,000? Di 100, di ba? So, kung minus 1,000 minus 100 square meters, kung 900 square meters or less ang i-deliver sa'yo, pwede mong i-cancel yung sale. As to yung 1/10 ng value ang kulang, ito medyo tricky yan kasi syempre ang value ng property nagdedepende yan, 'di ba? Alam naman natin na kapag bumili ka ng malaking lupa, kung yung harapan or yung front portion ng property mo na nasa kalsada, kadalasan yan yung pinakamahal, 'di ba? So hindi yan pantay-pantay yung presyo. Yung 1/10 ng value, I think that's a bit tricky, but if there is a way that they could find out kung less than 1/10 or more than 1/10 yung nawala doon sa napag-usapan ninyo, pwede mong i-cancel yung sale. Okay? Number 2, demand proportional reduction of the price. So, halimbawa, ang binigay sa'yo sabihin natin ang pinag-usapan ninyo, balik tayo, 1,000 square meters, ang ibinigay sa'yo 900 lang. So, dito, ang sitwasyon is, pwede mong i-cancel yung sale, or number 2, pwede mong hingin yung proportional reduction ng price. So, ang i-assume natin dito is, bawat portion ng property is pantay-pantay. Sabihin natin, tig 5,000 square meters. So, in this case, kung ang rate ng property is 5,000 square meters, diba, per 5,000 per square meter, tapos 1,000 square meters yon, edi i-reduce mo lang siya ng proportionate value nun. Ibig sabihin, 5,000 times 100 square meters. So, magkano yan? 5,000 times 100. 500,000. I-reduce lang ng 500,000 pesos yung presyo nung binili mo. Assuming na yun yung yun yung rate sa bawat portion ng bawat square meter na binili mo. Okay? So, that's very simple. 1540, this is related with the previous article 1539. Here, the real property delivered was more than what was agreed upon. In this case, the buyer has the following options. Number 1, to accept the area included in the contract, or reject the rest, or accept the excess, but must pay for the same at contract rate. So, napaka-simple din ito. Kagaya ito nung sa 1539, pero dito sumobra. Ang usapan ninyo, 1,000 square meters lang ang i-deliver sa'yo is 1,100 o kaya 1,050 square meters. So, may sobra na 50 square meters or kaya 100 square meters. In this case, yung first option mo, tatanggapin mo lang yung 1,000 square meters kasi yun lang naman yung napag-usapan. Tapos i-reject mo na yung iba, yung rest. Kung yung pangalawang option mo naman, pwede mo namang bilhin na lang yung sobra na 50 or 100 square meters at contract rate na assuming yung contract rate nyo is 5,000 pesos per square meter. Diba? So, ganun lang kasimple. In this case, yung buyer, hindi niya pwedeng i-rescind yung sale. Siguro kasi dahil ina-avoid lang yung situation na halimbawa biglang nagbago yung isip ng buyer, tapos ginawa ng buyer, sinobrahan niya. Diba? Tapos biglang sasabihin niya na, i-rescind na natin to kasi nagkamali ako nung declaration sa'yo. Siguro, ganun. But at any rate, hindi pwedeng i-rescind. Walang karapatan na mag-rescind or mag-cancel ng sale yung buyer. 1541. The provisions in 1539 and 1540 also applies to judicial sales. Yung judicial sales, yan yung mga sales na yung court yung nag-initiate ng sale. Okay? So, judicial sales are sales made by the court. For instance, a property is foreclosed. the court will then direct the sheriff to sell the foreclosed property to the highest bidder. Okay, so at this point pa, kung hindi mo naintindihan yung concept ng foreclosure, ipapaliwanag ko sa inyo. Kasi dati ako din hindi ko yan naintindihan. Pero napakasimple lang din uli niyan. Okay. Nagsisimula yan sa isang utang. Okay? Halimbawa, si A nangutang siya sa bangko ng sabihin natin 1 million pesos. Sa palagay mo ba papayag yung bangko na basta-basta na lamang magbigay ng 1 million pesos cash kay A? Ang sagot, syempre hindi. Kasi kailangan ng bangko ng security. Security na in the event hindi niya mabayaran yung kanyang utang, may pagkukuhaan sila ng pambabayad doon sa utang. Okay? So, ano ba yung security na hinihingi ng bangko? Yan ay kadalasan lupa. Okay? So, kung lupa yan, ang gagawin ng nangungutang is isasanla niya or imamortgage niya ang kanyang lupa. So, isusurrender niya yung original title ng kanyang lupa doon sa bangko. Tapos, tatatakan niya ng bangko na yung title na nalalagyan nila ng annotation yan na nagsasabi na may utang si A sa bangko ng 1 milyon at payable ito after 1 year. Okay? So, in the event na hindi magbayad si A ng kanyang utang after 1 year, tapos binigyan pa siya ng grace period o ng extra time ng bangko upang magbayad pero hindi pa rin talaga siya nakapagbayad, mapipilitan na yung bangko na mag-initiate ng tinatawag na foreclosure proceeding. So, ano ba yung foreclosure proceeding na yan? Ibig sabihin, yung lupa ay ibibenta ng korte. So, ang presumption niyan is pupunta pa rin sa korte yung bangko. At sasabihin niya doon, Your Honor, we are applying for a foreclosure, a judicial foreclosure of the property. Considering that it has already been more than 1 year since Mr. A promised to pay his loan, but he has not yet complied with his obligation. So, in order to satisfy or bayaran yung kanyang utang, we have no choice but we have to sell this property, okay, in an auction sale. Yan. Naintindihan pa so far? So, ngayon, yung property foreclose ng court. Ibebenta yan sa highest bidder. Okay? So, ang nagbebenta niyan, syempre, hindi mismo yung judge. Ang nagbebenta niyan is yung tinatawag nating sheriff. Hindi yan yung parang sa cowboy, Texas cowboy na may sheriff. Hindi yan. Ang sheriff, normal na tao lang yan. At wala yung parang star na nakalagay dito sa chest niya. Wala rin siyang barel. Okay? Ang sheriff is just an ordinary person na court-appointed. Malaki ang tiwala ng korte sa kanya na gagawin niya yung utos ng korte. So, ang gagawin niya is ibibenta niya yan sa highest bidder through a public auction. Okay? Tapos, dun sa pag nabenta niya na, dun sa highest bidder, dun sa public auction, kung magkano yung nakolekta or yung binayad ng highest bidder, yung amount, yung pera na makukuha doon, gagamitin pambayad ng kanyang utang plus interest. Tapos, yung sobra, ibabalik doon sa nangutang. Okay? So, ang sinasabi dito sa 1541, yung scenario na nakalagay dun sa 1539 at saka sa 1540, nag-a-apply din siya sa mga ganitong klaseng sale. Yung auction sale or judicial sale. Okay? Okay, sana may natutunan kayo dun. 1542, this still talks about a sale of a real property. However, contrary to 1539, which talks about a sale based on a certain price for a unit of measure, properties in New Manila are around 70k per square meters. Grabe, no? Sobrang mahal pala, no? Yung New Manila, dyan yan sa, malapit sa Trinity. Here, the price for the real property is fixed. Okay. Here, the rule is there shall be no increase or decrease in price, although there be a greater or lesser area. indicated in the contract. Okay? So, dito, okay. So, dito parang all-in yung bentahan. Kumbaga, hindi per square meter ang bentahan dito. Hindi kagaya dun sa Article 1539 saka sa 1540. Dito, all-in. Okay, o bilhin mo yung bahay ko. 5 million. Wala nang usap-usap kung magkano per square. Basta bilhin mo ganito. Okay? So, kung sumobra man yan o kumulang, wala ka nang magagawa. Kasi all-in yan eh. Hindi na pwedeng i-reduce. Hindi na pwedeng, hindi pwedeng, kung kumulang, hindi ka pwedeng humingi ng proportionate reduction. At kung sumobra, hindi ka rin pwedeng magbayad. Okay? 43. Actions arising from Articles 1539 and 1542 shall prescribe in 6 months counted from the day of the delivery of the parcel of land. Oh, wow, ayos 6 months period ka lang pala pwedeng magreklamo. Ang prescribe, ibig sabihin yan, hanggang dyan lang. Ang prescribe nanggaling yan sa salitang prescription. Okay? So, yung prescription or yung tinatawag na prescription period, yan yung period of time na pwede ka lang magdemanda sa korte. Hindi yan prescription ng gamot. Okay? Magkaiba yon. Dito, sa batas or sa law, ang ibig masabihin ng prescription period, yan lang yung period of time na pwede kang magdemanda. So, ang sinasabi dito, 6 months lang pwede kang magdemanda. Okay, ano ba yung ibang example ng magtataka ka? Talaga sir, may ganan, may prescription period. Oo naman, lahat ng reklamo, lahat ng cause of action, may prescription period yan. Well, at least, generally, halos lahat. Halimbawa, may sumantok sa'yo, di ba? So, ano yan, less serious, slight physical injury. Kung hindi ako nagkakamali, ang prescription period yan is 2 months lang. Okay? Pero yung mga mabibigat na crime like halimbawa murder, alam ko 20 years yan yung prescription period. So within 20 years from the time the crime was committed, pwede pa rin magdemanda. Pero yung mga maliliit na reklamo kagaya ng ganyan, parang 6 months lang 2 months lang ata yan yung prescription period niyan. Nagdedepende ang prescription period sa bigat ng ng offense. Okay? So, yan lang yung period of time na pwede kang magdemanda. So, dito, kapag sumobra o kumulang man yan, yung lupa na yung natanggap, hanggang 6 months lang pwede mong makuha. Okay? Okay, sandali lang babalikan natin tong 1542. Okay. So, ito yung tinatawag nating lump sum, yung bentahan. Okay. So, hindi, tama naman pala. Okay. No increase or decrease in price. So, okay na tayo dyan sa 1542, 1543, o 1544. Ay, nako, ito yung paborito parating tinatanong. Very, very important ito. So, here, an object was sold twice, meaning the seller sold it the first time to the buyer and then afterwards sold it again to buyer number 2. So, 1544, actually ito, it refers to 2 aspects Yung double sale, yung first paragraph niyan, it talks about movable property. And then number 2 is also it talks about immovable property. So, yung movable, yan yung mga sasakyan. Yung immovable, yan yung mga lupa or condominiums, ganyan. So, here an object was sold twice, meaning the seller sold it to the first time to the buyer, the first buyer, and then sold it again to the second buyer. So, ang tanong dito is, sino yung mas may karapatan? Yung una bang bumili o yung pangalawang bumili? So, Article 1544 is your legal basis kapag tinanong kayo nito. Pero bago ang lahat, kailangan muna nating i-determine kung yung item ba is, or yung object is movable or immovable. Kasi magkaiba yung rules nila. So, 1544, double sale of movable objects. This is very simple. The ownership shall be acquired by the buyer who first takes possession in good faith. If the buyer took possession but he was in bad faith, meaning he knew that the property was already sold the first time around, but he still purchased the property, then the other buyer has the right. So, madali lang yan sa movable object. Kadalasan, kung sino yung unang bumili ng property, siya na yung may-ari. We are assuming na in good faith yung unang bumili. Ito naman, double sale ng immovable property. If property is immovable, meaning mga lupa o kaya condominium, the ownership shall belong to, number 1, the first who registers the sale in good faith in the registry of property. Number 2, in the absence of registration, the first one who takes possession of the property in good faith. And then number 3, in the absence of registration in possession, the buyer who presents the oldest title, like deed of sale or tax deed, in good faith. So, napapansin mo, sa 1, 2, 3 na yan, in good faith yan dapat. Kung sino yung in good faith. So, dito, hindi pala ibig sabihin na ikaw yung unang bumili, ikaw na yung mas may karapatan. Kasi kapag babasahin mo, ang assuming na parehong parties in good faith, parehong buyers, pareho silang in good faith. Yung una na mag-register sa Register of Deeds, siya yung may-ari ng, dito Registry of Property, pero Register of Deeds na ang tawag natin dyan. So, bawat city may Register of Deeds. Okay? Kung sino yung unang mag-register ng sale sa Register of Deeds, siya yung mas may karapatan. At sa practice, totoo naman talaga yan. Kasi, once na bumili ka ng property, ang unang mong gagawin talaga dapat, pupunta ka sa RD. Doon sa RD or Register of Deeds, isusurrender mo yung deed of sale at saka yung original title. After which, yung original title ng property, makakancel yan. Bakit siya makakancel? Kasi papalitan na yung pangalan ng may-ari, which is ikaw na, yung buyer. Magiging, mapupunta na sa pangalan mo yung property. Mag-iiba din yung torrents title or yung TCT number niya. Transfer Certificate Title number, mag-iiba din yun. Makakancel din yun, papalitan niya ng bago under your name. Okay? So, kung sino yung unang mag-register in good faith, siya yung may-ari. Kaya, very important talaga na alam mo yung batas, ano? Kasi, halimbawa, assuming na wala kang alam sa batas, binili mo yung property na to kay A, di ba? Tapos, hindi mo alam. Kumpiyansa ka, tiwala ka sa kanya, na sa'yo na yung property. Tapos, sabihin natin, wala kang ginawa for a period of 1 year or 2 years. Tapos, the next thing you know, sabihin natin, binenta niya pala, nangailangan siya ng pera. Binenta niya ulit sa pangalawang kumare niya. Diba? Pagbenta niya dun sa pangalawang kumare niya, yung pangalawang kumare niya, assisted by lawyer, diniretso nila sa RD, nalipat ang pangalan ng property from the seller to the second buyer. Assuming na hindi nila alam na binenta sa'yo Kasi kung alam nila na binenta sa'yo yung property, hindi na sila in good faith. Okay? So, hindi mag-a-apply sa kanila yung order na ito. Okay? Pero, syempre, yung issue niya ng good faith or bad faith na yan, magiging disputable yan Pupunta talaga kayo sa trial court. Magiging madugo yun. So, para sa akin, para i-avoid mo na altogether yung ganyang scenario, as soon as bumili ka ng property, kuha ka kaagad na mag-aayos, diba? Maganda, abogado, law office. Yung ipaayos mo ng property, magbabayad ka ng konti, konti in relation to kung magkano mo ba binili yung lupa, diba? Para at least makakasigurado ka na na-transfer talaga sa pangalan mo yung lupa. Kasi once na ang lupa may TCT number na under your name, hindi na yan malilipat kahit anong tumbling nila gawin. Kahit anong tumbling ang gawin dyan. Kahit 10, 100 tao pa nag-squat dyan sa property na yan, hindi yan matatanggal sa pangalan mo. Kasi, protected ka na ng torrents title. Okay? TCT. So, yung discussion na yan, property law. Actually, land registration laws yan. Habang nag-law school ka, dadaanan mo rin yan. So, napakaganda ng law kasi napaka-broad niya eh. And, sa akin, sinusubukan ko talagang i-integrate yung iba't ibang aspeto ng law para mas maintindihan ninyo yung pinag-aaralan natin kasi nare-relate ko siya sa ibang fields eh. Diba? Okay? 1544. So, we're done with Section 2, Delivery of the Thing Sold. Let's now move to Section 3, Condition and Warranties. Conditions and Warranties. Okay? Maiksi lang ata ito eh. Ay, parang hindi. Okay, sige, let's see. So, 1545. It talks about conditions. So, what is a condition? So, babalik tayo sa oblicon. A condition is a future and uncertain event. In contrast to a period is a future and certain event. Specifically, a suspensive condition means that if the condition happens, an obligation will arise. So, a contract of sale may also have a condition too. So, if it does have a condition, that's what you call a conditional sale. This means if the condition does not happen, then the obligation of the party in the sale will not arise. Okay? So, kailangan mangyari yung condition, which is yung future and uncertain event, para yung obligation ng parties mag-arise or mag-trigger. So, what happens if the condition in a conditional sale is not fulfilled or is not complied with? The other party may rescind the sale or still proceed with the sale, but he could just waive the performance of the condition. So, 1546, it talks about warranties. An express warranty is any affirmation of fact or any promise by the seller relating to the thing. This is usually made to induce the buyer to purchase the thing, and the buyer thus induced purchases them. So, di ba kapag bumili ka halimbawa ng refrigerator, usually yan eh. Ang unang tinatanong ng nanay mo may warranty ba ito? Di ba? Yung mga appliances. So, ibig sabihin yan, kung may depekto yung item, pwede mong ibalik. Yan yung warranty. O, di ba? Na-apply din natin sa may legal concept pala yung tinatanong ng nanay mo. Pero mas maiintindihan natin dito. So, sa 1546, it also about talks about an expression of opinion. There are usual exaggerations in trade when the other party had an opportunity to know the facts that are not themselves fraudulent. Okay, lagyan lang natin ng R. These are not considered warranties since the buyer knows that they are mere exaggerations. So, i-differentiate mo yung exaggeration sa warranty. So, yung exaggeration sa advertisement, example niyan is the cigarette that gives you utmost smoking pleasure. So, exaggeration yun, of course. The most effective painkiller, of course, that's another exaggeration. Okay? The best burger in the world, parang ganun, exaggeration. So, 1547 talks about implied warranties in sale. So, what are these implied warranties? Pag sinabi mong implied, hindi nakasaad, hindi yan expressly stated. Implied siya. Okay, implied warranty as to the seller's title, implied warranty against hidden defects or unknown encumbrances, implied warranty as to fitness or mercantability. Okay, so, again, law on sales ito. So, wag mong lilimitahan yung understanding mo ng warranty na limited lang sa appliances. Kasi yung warranty na yan, pwede yan mag-extend sa bahay o kaya sa lupa na yung binili, sa sasakyan. Okay? Implied warranty are not applicable in as-is, where-is basis sale or second-hand sale of articles or sale in a public auction with respect to the sheriff or the auctioneer. So, yung mga as-is, where-is basis or yung second-hand sale, yan yung pagpupunta ka ng ukay-ukay. As-is, where-is basis yun eh. O kaya yung second-hand sale, pupunta ka sa kapitbahay mo dahil nag-garage sale sila. Diba? Ito naman yung sale and public auction. Yan yung sinasabi ko kanina na yung sheriff yung nagbebenta. This means that the seller makes no warranty as to the quality or the workable condition of the goods. Usually, these items are priced significantly lower than the market value. Kaya naman pala, kasi mas mura talaga. The rule is caveat emptor. Let the buyer beware. O mag-ingat ang bibili dun sa bibili niyang item. Applies to execution sales. Since the sheriff does not warrant title to or the real property sold. Okay? So, sa conditions and warranties, may subsection yan, warranty in case of eviction. So, dito, 1548 talks about warranty in case of eviction. Ano ba yung eviction in the first place? So, eviction is a judicial process whereby the buyer is deprived of the whole or part of the thing purchased. So, yung bumili, sinipa siya mismo dun sa lupa na kanyang pinagbilhan. Okay, so this means that the buyer bought the property, thereafter the same was taken away from him. This is eviction. The warranty against eviction is to give the buyer remedies in the event that that situation happens. Okay? So, essential elements of warranty against eviction. The vendee is deprived of whole or in part of the thing purchased. Number 2, he is so deprived by virtue of a final judgment. So, this means that there was a case that was filed in court and the judge has already rendered a decision evicting the buyer from property. O, napakasaklap nga naman, bumili ka ng lupa, pagkabili mo ng lupa, biglang may kaso pala, tapos natalo ka sa kaso, tapos biglang sinipa ka dun sa property na binili mo. Diba? Sobrang saklap nun. Number 3, judgment is based on a right to prior to the sale or an act imputable to the vendor. So, ibig sabihin yan, may kasalanan yung vendor, an act imputable to the vendor. And then number 4, the vendor was summoned in the suit for eviction. So, yung sa kaso na yan, ng eviction case, sinervan ng subpoena yung vendor para mag-appear sa hearing. Okay, there is no waiver of warranty against eviction on the part of the buyer. Okay, so ang kino-contemplate nitong situation na to, ikaw ay bumili ng property sa isang seller, tapos biglang hindi mo alam, nagkaroon pala ng kaso, at biglang natalo ka pala dun sa kaso, tapos biglang sinipa ka dun sa property na binili mo. Diba? Dapat lang may karapatan ka. Diba? Kasi hindi mo naman malalaman kung may kaso yung isang property na binili mo, diba? Wala naman yan nakalagay sa titulo, diba? Hindi naman yan kagaya ng foreclosure or ng mortgage na nilalagay yan sa likod ng title. Kapag may pending case ang isang lupa, hindi yan nakalagay sa title. The only time nalalagay yan sa title is kapag inannotate yan. Okay? So, kapag hindi inannotate yan o hindi nilagyan yung likod ng title, paano mo malalaman? So, 1549, the buyer need not appeal from the decision of the court in order that the seller may become liable for eviction. When a case is in court, and there is a decision rendered, the losing party may appeal the unfavorable decision. In this case, even if the buyer did not appeal, the seller will still be liable to the buyer for the latter's eviction. Ang sinasabi lang dito, kahit natalo ka dun sa kaso, kailangan kang panagutan nung nagbenta sa'yo ng property or ng seller. When adverse possession by the third person has been commenced before the sale but prescriptive period is completed, after the property was transferred to the buyer, the seller shall not be liable for eviction. Okay, ulitin natin na. When the adverse possession by a third party has been commenced before the sale, pero yung prescriptive period is completed after the property was transferred to the buyer. Adverse possession. Then the adverse possession by a third person has been commenced, but before the sale. But the prescriptive is completed after the property the seller shall not be liable for eviction. Okay. Ang ibig sabihin nito na ilipat na yung property doon sa buyer, sa'yo as buyer. At yung kaso nung magdedemanda, nag-prescribe na. Pero after na mag-prescribe, nagsampa pa rin siya ng kaso. Ang sinasabi dito, hindi na mananagot yung seller kasi prescribe na. At any rate, kung magkaso man siya dun sa buyer, ang gagawin lang ng buyer, i-manifest niyan sa court na prescribed na yung case. Again, what is prescription? By prescription, one acquires ownership and other real rights through lapse of time. In the same way, rights and actions are lost by prescription. So, yan yung sinasabi ko. Rights and actions are lost by prescription. So, conversely, may mga rights din na na-acquire because of prescription. At may mga rights din na nawawala dahil nag-prescribe na. So, S, example. Si S, nagbenta siya ng lupa kay B. Walang titulo. Ngayon, si C, kiniklaim niya na yung lupa na yan na walang titulo ay at kanyang tinitirahan continuous possession of the said parcel of land for the past 30 years. Ang sinasabi niya na under the law, C is deemed to have acquired ownership of the land by prescription. In this case, if S, the seller, sold the land to B after the 30-year period has lapsed, S is liable for eviction. In this case, if the seller sold the land to B, to the buyer, after the 30-year period has lapsed, the seller is liable for eviction. Why? Kasi yung right nung C, pipigilan ko kayo ha, kailangan ko lang linawin ito. Totoo ito eh. Under the law, kapag ang isang lupa ay walang titulo, yun yung pinaka-crucial eh, walang titulo. Kung walang titulo ang lupa, tapos may isang tao dyan na nag-squat and that person has continuous, open, notorious, and may letter E yun eh, C-O-N-E yung aking acronym doon dati. Continuous, open, notorious, and letter E, I forgot. Stay or possession over the property. He has the right to own that property. Okay? So this right, he has earned the right to own the property by virtue of prescription. Okay? Tama yan. As long as yung property walang title. Kaya nga very, very important na papatituluhan mo eh. Para kahit na magstay siya dyan ng 100 years, kung nakapangalan sa iyo yung lupa, wala talaga siyang karapatan. Okay. So, ang sinasabi dito, binenta ni seller kay buyer yung lupa bago mag-lapse yung 30-year period na yan. Ibig sabihin, wala pang karapatang magdemanda yung squatter, si C. Okay? Wala pa siyang right sa property kasi wala pang 30 years. Sabihin natin, binenta niya on the 25th year. Ngayon, ito si buyer, may obligation siya na patituluhan na yung property. At may obligation din siya na magstay na at i-possess yung property. Kung hindi niya ginawa yon, at after ng 30 years, meaning yung 30 years na nagsistay yung squatter or yung letter C, pwede na magdemanda si C. In this case, wala nang liability si seller. Kasi may 5 years si buyer na ayusin yung yung title. Hindi niya ginawa, di ba? So kasalanan yun ni buyer, kaya siya napunta sa sitwasyon na ganyan. Pero kung binenta niya after yung 30-year period na yun ay naglapse at may right na yung squatter dun sa property, edi may liability ngayon si S, 'di ba? Kasi may warranty siya against eviction, 'di ba? Mina-warrant niya na walang problema yung walang kaso dapat yung lupa. Pero since tinransfer niya after the 30-year period has prescribed or has lapsed, may kaso na yung property, 'di ba? So may liability ngayon si seller. However, if S sold the said parcel of land to B at the time that C was only occupying the land for 25 years, S is not liable to B since B could file an action against C before the lapse of the 30-year period which grants the occupant ownership of untitled land. Ayan. So may 5 years nga si B na i-consolidate or i-transfer yung ownership ng title sa kanya And at the same time, meron din siyang 5 years para i-evict yung mga squatters na nakatira dun sa lupa na kanyang binili. Kung hindi niya ginawa yan, kasalanan yun ni B. Walang kasalanan doon si seller. Pero kung si seller, pinatapos niya yung 30 years, tapos after ng 30 years na yon na pwede na siyang habulin ng mga occupants or ng mga squatters, binenta niya yung property kay kay B pala, may liability siya doon kasi in bad faith siya di ba? Okay. 1551, if the property is sold for non-payment of taxes due and not made known to the buyer before the sale, the seller is liable for eviction. Okay, generally when real estate tax or familiar property is not paid for an unreasonable amount of time, the local government may sell the said property in a public auction. The proceeds of the sale will be applied to the payment of taxes. In the present case, if the buyer is deprived of ownership of the property because it was sold in a public auction due to the non-payment of taxes by the seller is liable for eviction to the buyer. So, most likely, ibabalik ni seller yung lupa. Okay, pipigil muna tayo dito ha. Papaliwanag ko lang ito kasi nagkaroon ako ng kaso dati ng kagaya ng ganito. Kapag ikaw ay may-ari ng lupa, may binabayaran ka dapat na real estate tax every year. Ang tawag dyan ay amilyar. Maliit lang naman yan, pero kung halimbawa 10 years mo nang hindi binabayaran, medyo lumalaki din talaga. Okay? Kapag hindi mo binayaran yan, yung amilyar mo for an unreasonable length of time, siguro mga 5 years or 10 years hindi mo binayaran, ang mangyayari niyan, parang kagaya din sa foreclosure. Ibibenta ng government yung lupa mo sa public bidding, tapos yung proceeds gagamitin pambayad ng utang mo at yung balanse ibabalik sa'yo. Okay? So, nangyari yan sa isang kliyente ko kasi bumili siya ng isang lupa dyan banda sa may Fairview. Tapos, bakanting lote lang naman. Ang nangyari sa kanya, lumipat siya ng bahay pagkatapos. So, yung mga letters galing sa office sa Quezon City na sinasabing magbayad siya ng tax, hindi niya inasikaso. Hindi niya natanggap kasi nga naglipat siya ng bahay. Pangalawa, never naman siya nag-update ng kanyang tax although obligation niya yun na magbayad ng amilyar every year. Next thing she knew, nung pumunta siya dun sa property niya, kasi malayo yung bahay niya taga-south siya, diba? So, nung napadaan siya dun sa property niya, nagulat siya kasi iba na yung may-ari, sold to something, diba? May nakalagay na doon, this property is sold, ganyan. Tapos, nag-inquire siya. It happens na hindi pala siya nakapagbayad ng parang 5 or 10 years ng amilyar. So, finar-close ngayon ng government yung property niya. So, kawawa, di ba? Ngayon, yung kino-contemplate ng Article 1551, halimbawa yung ganyang example, hindi nakapagbayad ng amilyar si landowner, si A, yung seller. Tapos, nung binenta niya yung property kay B, si B naman binili, akala ni B in good condition, biglang nagulat siya, pinpublic auction na pala yung property. Di nakuha din sa kanya yung property. So, in this case, liable si A for eviction. Ang mangyayari siguro niyan, babalik niya yung pera, yung purchase price kay buyer. Okay? 1552, the judgment debtor is also responsible for eviction in judicial sales. This is based on the principle of unjust enrichment, wherein a person shall not be unjustly enriched at the expense of another. If a person has bought a property from public auction and thereafter was evicted because the judgment debtor had no right over the said property, the purchaser may recover from the judgment debtor. Siguro ito yung mga, hindi ko rin alam kung ano yung kino-contemplate ng scenario dito. Judgment debtor is responsible for eviction in judicial sales. So, ang judgment debtor kasi siya yung inutusan ng court na magbayad ng utang. So, siguro dito, if a property bought in a public auction, it was evicted because the judgment debtor has no right, the purchaser may recover from the judgment debtor. Baka siguro para makapagbayad ng utang, Ang ginawa ni judgment debtor, binang bayad niya yung kanyang lupa na marami palang utang sa amilyar, di ba? So if that's the case, he can still be liable for eviction. 1533. Any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Bad faith is present when, for instance, the seller knew before the sale certain facts that will give rise to eviction. So I just want to stress out that in all your actions, you always have to be in good faith. Okay, hindi mo na, yan lang maganda kapag alam mo yung batas para hindi mo kailangan magtago, di ba? 1554, kinds of waiver of eviction. So you have your consciente or intentionada. Yung consciente, the waiver is involuntary and is made by the buyer without the knowledge and assumption of risk of eviction. So here, the seller is liable to pay the value of the things sold at the time of eviction. So ito yung remedy. Yung seller, babayaran niya kung magkano yung bagay na nawala at the time of eviction. Intentionada, the waiver is made by the waiver is made by the buyer with knowledge of the risk of eviction. So here, the seller is not liable to the buyer unless of course the seller was in bad faith. Okay, so dito may tinatawag na dalawang klaseng waiver. So a waiver in naturally is something which is you do voluntary. Ang waiver means wini-waive mo yung right mo magdemanda. So voluntary yan dapat. So kung consciente, the waiver is involuntarily made by the buyer without knowledge and assumption of risk of eviction. So I don't really know why you still call it a waiver if it's involuntary in the first place, diba? Probably he was presented by a document which he does not know but he just signed it, diba? Possibly ganun. Yung intentionado naman, alam naman nung buyer na may risk of eviction yan. Okay, I'll give you an example. Parang naalala ko dati dun sa subdivision na nakatira ako, may mga lupa doon na binibenta. Tapos nabalitaan ko, mura daw yung benta ng property. Parang yung benta is 3/4 ng price ng property. So, tinanong ko kung bakit mababa. Kasi malaki yun yung 1/4 if you're talking about millions. Imaginin mo kung 20 million yung property, binili mo ng 15 million. Diba? Nakatipid ka ng 5M. So, dito, ang sabi daw, dito sa intentionada, alam nung buyer na may risk of eviction. So, alam niya na may kaso. At alam niya na posibleng matalo yung kaso. Diba? Kung ganyan ang pangyayari, hindi na siya pwedeng maghabol dun sa buyer. Sa seller. Kung natalo eventually. Kasi para siyang sumugal niyan Bumili siya ng property na alam niyang may posibilidad na matanggal sa kanya, pero mas mura niya binili. Actually, may nahawakan akong ganitong property sa kaibigan ko Bumili siya sa BPI ng mga lupa na binibenta. Tapos, alam niya na may kaso yung lupa. May nagdedemanda Pero, pinareview niya sa akin yung kaso. Tinanong niya yung opinion ko kung malakas ba yung kaso nung nagdedemanda o mahina. So, sinabi ko na mahina yung kaso nung nagdedemanda kasi kulang yung ebidensya nung nagdedemanda. So, malamang madidismiss yan, yung demanda. So, ibig sabihin, yung ownership ng property, hindi mawawala dun sa seller. So, ang ginawa niya, binili niya yung property ng mas mura. Parang, hindi ko alam kung 1/2 yung price or 3/4 yung value Parang ganun. Nakatipid siya. Ako din yung humawak ng kaso. Napadismiss ko din yung kaso. So, pag titingnan mo, malaki nga talaga yung kinita niya doon. Diba? Okay. On hindsight, dapat pala mas malaki yung siningil ko. Okay. Next na tayo. So, yun yung consciente at saka intentionada. So, what are the rights of a buyer in case of eviction? So, 1555 discusses this. 1555, when the warranty has been agreed upon, or no this has been stipulated on this point, in case of eviction occurs, the buyer shall have the right to demand the seller of... Titingnan ko lang ano ba yung 1555 na yan? On this point. Okay, when the warranty has been agreed upon, or on this, when the warranty has been agreed upon, or nothing has been stipulated on this point, in case of eviction occurs, the buyer shall have the right to demand the seller, number 1, the return of the value at the time of eviction, number 2, income and fruits, number 3, cost of suit o yung demanda, number 4, expenses of contract, and number 5, damages and interest. Tama naman yan. Tama naman. Return the value of the thing at the time of eviction. Tama din naman. Kasi alam naman natin yung lupa, tumataas yung value. Kung return the value of the thing at the time it is bought, parang lugi naman yung nun, yung buyer. Okay. 1556 talks about partial eviction. This means that only a part of the thing sold was evicted or removed. The buyer may, number 1, enforce the buyer's liability for eviction as stated in Article 1555, or he just may altogether say, tayo ko na nito, cancel na lang natin. Demand rescission. 1557, the warranty cannot be enforced until final judgment has been rendered, whereby the buyer loses the thing acquired or a part thereof. So, kailangan mo talagang pumunta ng korte kasi nakalagay cannot be enforced until a final judgment has been rendered. So, kaso talaga to sa court. Sa totoo lang ayaw mo to gawin kasi ayaw mo tong gawin kasi napakatagal ng civil cases 1558, the seller shall not be obliged to make good the proper warranty unless he is summoned in suit for eviction. The reason behind the law is due process. The seller is given an opportunity to defend himself from the action against him. So, kung may nag-i-evict doon sa buyer, dapat furnish na rin ng notice itong seller para yung seller makapasok doon sa kaso, so that the court can acquire jurisdiction over the seller and give the seller an opportunity to be heard, to explain his side kung bakit ganun yung nangyari, kung bakit nagka-problema. 1559, the defendant buyer shall ask within the time fixed in the rules of court for answering the complaint that the seller be made as co-defendant. Tama naman yan. Ito medyo procedural na ito. 1660, the right of a buyer where immovable has an encumbrance which is not apparent or seen. The buyer has the following options. Number 1, to rescind the sale, or number 2 is ask for appropriate indemnity, o indemnity is kabayaran. Ano ba yung encumbrance? Encumbrance is a burden, so it's usually an easement. Sabi mo, nalito na ako. So, yung encumbrance, siya? It's a burden. Okay, usually an easement. Pwede ding mortgage yan. Imposed on a real property. Yung easement yan, yung easement of right of way. So, yung mga enclosed kasi na properties, may right sila na humingi ng easement of right of way doon sa harapang property na papunta ng kalsada. Okay, yan yung easement of right of way para makalabas-pasok sila at yung sasakyan nila kung nasa loob sila ng property. Okay, so it is a burden imposed on a real property. This is usually annotated or written at the back of the title of the property. Tama yan, naka-annotate talaga yung mga encumbrance sa property. So, halimbawa dito, where the rights of a buyer were immovable sold as encumbrance, which is not apparent or seen. So, yung buyer, bumili siya ng lupa, tapos pagkabili niya ng lupa, hindi niya alam na may utang pala yung lupa, diba? Kung ganyan, pwede niyang ibig sabihin, pag sinabi may utang yung lupa is sinangla pala yung lupa. Okay? Ginawang ano yung lupa, subject ng, or minortgage yung lupa para ma-secure yung loan. So, kapag nalaman niya na ganyan, he can rescind the sale. Kasi sabi, not apparent or seen. Pag sinabi mo kasing easement of right of way, pag pumunta ka dun, nag-ocular ka, makikita mo yung easement of right of way. So, palagay ko hindi ito yung kino-contemplate ng Article 1660. Ang kino-contemplate niya is yung encumbrance na hindi nakikita. Okay? So, siguro, yan yung may utang yung property, tapos may utang yung seller or yung may-ari ng property, tapos minortgage niya yung property na to. Tapos yung buyer naman, binili niya na hindi niya alam na naka-mortgage pala yun sa bangko kasi hindi pa naka-annotate. Okay, so I have a few questions here. I usually give this before sa class nung panahon na nagkikita-kita pa tayo in person. Anyway, you can try to answer this. It's very helpful. So with this, we will end this particular portion of our discussion, and I'll see you again next time. Thank you.